Good evening. This is Making the Case. I'm Yodit Tewolde. Developing news tonight coming out of Brunswick, Georgia. Jurors in the trial of the men accused of killing Ahmaud Arbery could be close to reaching a verdict. Thea Brooks, Ahmaud's aunt, tells BNC the jury initially asked to work late tonight because they might have been close to reaching a verdict. But shortly after, the judge stepped in and told jurors to come back in the morning. What could this mean for the prosecution, defense, and the Arbery family? I've got my panel of experts standing by ready to weigh in. But first, we're following two breaking stories we've covered here on Making the Case, and they come with some welcoming news. Starting with the case of Kevin Strickland, who spent the last 43 years behind bars in one of the longest wrongful conviction cases in U.S. history. An all-white jury in Missouri convicted him for a 1978 triple murder. Strickland has long insisted he was home watching TV when the crime occurred. In fact, two other men who were also convicted in the case admitted that Strickland wasn't there. Even a survivor of the shooting reportedly recanted her ID of Strickland. A new law allowed the district attorney's office to advocate for Strickland's release. That finally happened just a few hours ago when a judge tossed out the conviction and sent Kevin Strickland home. Here's what he had.
It needs to be torn down and redone. Just from the arresting officer to the presiding judge. I mean, it don't work. I mean, it worked here in the long run, but it took 43 years to get here.
Strickland said he is now looking forward to spending Thanksgiving with his family. Also breaking tonight, a man who won elected office while behind bars is also free. This is video of the moment Joel Castone walked out of jail in Washington, D.C. last night after 27 years. Castone was convicted of murder back in 1996, though he's maintained he was wrongfully convicted. And instead of giving up, he gave back. He took classes, learned new languages, set up a mentorship program, and eventually won an election to D.C.'s Advisory Neighborhood Commission, all while being incarcerated. Shortly after his release, Joel said, quote, "It hasn't been 27 years of waiting to go home. It's been 27 years preparing myself to never come back to prison again." All right, now back to the big story in Georgia. The jury now has the case against Travis McMichael, Gregory McMichael, and William Bryan, beginning the deliberation process just before noon today, and it appears they're close to a decision. Jurors listened to 10 days of testimony in a trial that began with nearly 3 grueling weeks of jury selection. I've got my team of legal experts with me through the hour for a breakdown of how this trial has unfolded. Paul Henderson is a veteran prosecutor and BNC's legal contributor. CK Hoffler, a trial attorney and the immediate past president of the National Bar Association. And Robert Swafford, an attorney and jury consultant. Welcome to you all. Let's get started, all right? Starting with a clip of lead prosecutor Linda Dunikoski. She gave her closing arguments rebuttal this morning. Take a listen.
They know what they did. It's not like they don't know what they did. They know exactly what they did and they know why they did it. It's not a mystery to them. When you come back with your guilty verdict, all you're doing is telling them, we know what you did too. And we're going to hold you responsible for it. Because guess what you did? You turned this young man into that young man. That's what you did. For absolutely no good reason.
There was, I don't know if you guys caught that, but there was a sound that was coming from the gallery in the courtroom, and that was Ahmaud Arbery's mother reacting to the side-by-side photos of her son alive next to the photo of his dead body. Nothing drives the point home than visuals. CK, to you first. Your thoughts?
Absolutely. I think that was a particularly powerful way to end her rebuttal closing. A picture is worth 1,000 words, and for her to end after really basically setting out the case for the jury as to why they needed to convict each of the defendants, to end in that way was very compelling. I'm sure it was devastating for the family to see. It's going to be devastating for them to remember over and over and over those scenes. But for purposes of getting convictions, it was very, 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 very compelling.
Paul, I've said this before with you, I believe, that it's important for the prosecution to humanize the victim in the case, and that's by portraying them as just a regular individual, showing a picture of them while they were actually living and happy, instead of photos of them bloody and on the ground. The prosecution did this at the end. Was that a missed opportunity for them to present Ahmaud while he was living throughout the trial?
I think it's a mixed bag, and we've had conversations about this. And normally, or especially in a case like this, when you have a homicide, it really is important to try and paint a picture, because you are that victim's voice in the courtroom. And obviously, with his family there and with the community there, you want to respect the memory. You want to respect that person, especially when that person is under attack. And Ahmaud Arbery, let's make no bones about it, has been under attack the entire time throughout this trial from the defense attorney. This, however, was somewhat of a fine line that prosecution had to walk in making her rebuttal. And she did a really thorough and deep dive into outlining the legal issues, understanding or why the defendants were guilty. And I know that folks have said that I wish she had focused more on Ahmaud, and they wanted her to talk maybe a little bit more about race. But I think one of the things that she had to be conscious of is this jury in particular, that the defense attorneys had removed 8 of the Black people that would have served in that pool, and there was only a singular Black person there. So she really had to balance between arguing against what defense was trying to present and drifting into a race analysis that might have alienated this jury in particular. I think she did a really good job and a good presentation. I'm hoping we get a quick verdict.
Robert, besides the effect of having graphic photos shown to a jury and what that could do for the jury, what about the reactions coming from loved ones in the courtroom? Effective? Is it a distraction?
Well, here's what I would say is that I believe that for the most part, the jurors have made up their mind by closing argument. And so outbursts by or just emotional reactions by family members in the courtroom, things that the prosecutor or the defense is saying in closing, isn't really about changing minds at that point. What it's about is giving the people who are on your side the tools they need to go back and argue and prevail. So if you think back to the Kyle Rittenhouse verdict, they were out for 3.5 days, right? So what that means is there were people who are arguing for one side and people who are arguing for the other side. And so the question is who was going to give in and who was going to prevail. So it's not so much about persuasion as arming your jurors when they go back into the room. And I think the prosecutor did a really good job by using not just visuals that provide like an emotional response, but also I watched the rest of the closing argument, and she had visuals outlining the path that people took. They played videos and replayed the videos and analyzed where people would have had to have been standing. And so she did a very analytical job and also laid out the facts in a very logical, calculated presentation, because I think that what she wants is for the people who are for conviction to go back and have all the tools they need to come to the correct conclusion.
Well, I've got a follow-up for you, Robert, but before, because I want to get y'all's assessments of the prosecution's rebuttal, but I want to ask you first, Robert, setting aside the overwhelming evidence of guilt for a second, did the state, or does the state, have a slight edge over the defense because they had a night to prepare against the arguments made by the defense, and the jury only heard from the prosecution. So is that a slight edge over the defense?
Well, there's the rule of primacy and recency. So the first thing you hear makes a big impact, and the reason the first thing that you hear makes a big impact is because there's something called a bias, where you tend to come to a quick conclusion and exclude information that's inconsistent with the conclusion you've already come to. So going first has a power, but also going last, because the last thing you hear is the thing that you take out of the courtroom with you. But I will tell you that if the lawyers are doing their jobs, and I think the prosecution certainly have been doing their job, they have been preparing this closing argument for months.
All right, now to the rebuttal. CK, did the prosecution hit the most important points? Were there any missed opportunities in your opinion?
I think she really did hit the most important points. Not only did she hit the most important points, I think she knocked it out of the ballpark. She, in a very systematic, affable way, if you will, she was talking about a very, very difficult subject, something that really no one wanted to hear when you think about the gory details of this case. She addressed the citizen's arrest, and she completely dismantled the defense of citizen's arrest. She completely dismantled the defense of self-defense. But then she went further. She took all of the arguments and she said, okay, this makes no sense. This makes no sense. This makes no sense. But let me tell you what does make sense. And she piled in all of that evidence so that the jury really should only reach one conclusion: conviction of all three, without a question, without a doubt, on all counts. And her demeanor, her courtroom presence is very, very disarming. Sometimes she had righteous indignation. She had excellent use of visuals, from the little flip chart where she had her handwritten notes, to the videotape, to just looking at the jury and saying, we know this doesn't make sense. This is crazy. So call it for what it is. From your verdict, say, look, I know what you did. You know what you did, and you know that I know what you did, and now everybody knows what you did. So give us the verdict so that the world can say, yes, justice is served. We all know what you did, and it's not right, not in these United States of America. And she put that all in a nice little bow for the jury. And again, the last one to be heard. And so I think it was very powerful.
What I also thought was really powerful, Paul, about her rebuttal is the fact that she told this jury when they come back with a guilty verdict. So she's already claiming, y'all are going to come back with a guilty verdict. This is not about a person being good or bad. It's about being held accountable and being responsible for your actions when you break the law. Your thoughts?
And when she did that, as a good trial attorney does, is you weave in your argument, you connect it to a fact and a known fact, or a commonly agreed upon fact, which is what she did. So they're more accepting of what you're saying. I love the way that she slid that in, and that is one of the advanced trial techniques that prosecutors frequently use. I thought it was executed well, no pun intended, but let's hope that it was received well, that the jury was catching and picking up what she was putting down. I truly believe that the best vindication, affirming that this prosecutor did a good job, is coming back with a verdict quickly that doesn't take too long and that will be guilty. Because we all saw, I mean, there's not a lot of ambiguity as to what happened. And that's just a reminder. It's one videotape. We all saw what happened. There are different perspectives about what was happening, but we all saw it. We all know what it was. And to the degree we have any doubt about what we saw, defense attorneys have made it very clear that their racist interpretation of what they saw on the tape is not the same reality that I think most of the rest of us saw as well. And so I think the prosecution did a good job. I think she laid out her argument and tied it to the facts, and at the same time dismantled the approach that the defense attorneys were trying to present to the jury, which, by the way, was a distraction and not focused as much on the evidence or the facts, but a distraction to them to follow some presumptions that aren't appropriate and ended up being racist to everybody else. So let's see what happens next.